Hello everyone, in part 7th of the Current Affairs series, we are going to talk about the proposed amendment in the Disqualification Act of MP.
Let's first see why this is in news.
Government plans to reenact law on disqualification of MPs over office of profit on the lines of recommendations made by the Joint Committee on Office of Profit headed by Kalraj Mishra on the 16th Lok Sabha. The draft bill seeks to replace the Parliament Prevention of Disqualification Act 1959. According to the Constitution, an MP or a state legislature will be disqualified for holding an office of profit under the government unless that office has been exempted by law. An office of profit is a position that yields financial gain or advantage to its holder. In 1959 Act lists offices whose holders are exempted from being disqualified as Member of Parliament and state legislature. It also specifies positions that would result in disqualification. The law has been amended several times in 1960, 1992, 1993, 2006 and 2013. The key features of the draft bill include list of offices under the Act. Offices that are exempt from disqualification include: first, offices held by minister; second, offices of the leader of opposition and a whip; and third, chairperson of the National Commission for Scheduled Caste and Tribes, Women and Minorities. The draft bill adds a faculty or senior member of the university to the list. It also lists offices whose members are exempted from disqualification. The existing Act also lists offices that are not exempt from disqualification. The draft bill removes this list. Power to amend the list. The draft bill empowers the central government to amend the list of offices exempt from disqualification. Temporary suspension. The Act prevents a member from disqualification if he held an office that was exempt prior to the Act but was reserved later. The MP must resign from such office in 6 months. The draft bill removes this provision. Now let's see, according to the definition, what constitutes an office of profit. The term office of profit lacks a clear legal definition, evolving through court interpretations. It refers to position offering financial gain or benefit regardless of amount. The Supreme Court holds the authority to decide related cases. The Supreme Court's 1964 test of appointment considers various factors to determine if a position qualifies as an office of profit. Several factors are: first, whether the government is the appointing authority; second, whether the government has the power to terminate the appointment; third, whether the government determines the remuneration; fourth, what is the source of remuneration; and fifth, the power that comes with the position. Now, let's know, what does the Constitution say about holding the office of profit? Under the provision of Article 102, Clause 1, Subclause A, and Article 191, Clause 1, Subclause A of the Constitution, an MP or a member of a state legislature is barred from holding an office of profit under the central and state government. The article clarifies that a person shall not be deemed to hold the office of profit under the Government of India or the government of any state by reason only that he is a minister. The Constitution specifies that the member of ministers, including the chief minister, has to be within 15% of the total number of members of the assembly. In case of Delhi, it is only 10%. For more details on this topic, you may refer YouTube video on the topic Office of Profit, or you may click on the link given in the pinned comment and YouTube description. That's all for today. For more such video, stay tuned to GS NEXUS.